Hello and welcome to session 1. We're going to go ahead and get started today, and we're going to do that with starting to talk about some acronyms. Now, I have to tell you, the child welfare world lives on acronyms like the military and medical and so many others. And so as you go through this training, there are certain acronyms that you're going to need to learn and understand. First one is CASA or GAL, and that is actually how that is pronounced, GAL. Well, in some states, this CASA volunteer advocate position that you are training to become is actually considered a guardian ad litem, a GAL. And therefore, sometimes you will see, like on the slide up on the top left corner, where it says CASA/GAL. If you see that in this training anywhere, you need to understand that it's talking about you as the CASA volunteer advocate. In the state of Kansas, we are considered CASA volunteer advocates or CASA advocates. In other states like North Carolina, they are GALs. So please keep that in mind. In the state of Kansas, we actually have an attorney position that is a guardian ad litem, and that's who we refer to as the GAL. So don't be confused by this. Just know that it's going to happen. But this isn't the only time in training you're going to see some acronyms and letters that may or may not make sense to you. For instance, in the state of Kansas, we have the Department for Children and Families. Now, these are the state social workers that will investigate child abuse and neglect cases. They are involved with the case. However, other states, for instance, like Texas, call it Child Protective Services. In Kansas, there is a small division within DCF, that is Child Protective Services, but we actually don't even interact with those workers very much. That's a different kind of a job. We will interact with potentially DCF workers. And so that can become confusing, but some of our case plans and some of our training cases will say CPS, and so I want you to be completely aware that that's what we're talking about. We're talking about our DCF workers. Now, the other thing that you're going to find is sometimes different states use different terms for the same thing. For instance, you'll have DUIs or DWIs, driving under the influence versus driving while intoxicated, and it has different meanings in different states. Well, guess what? It's no different here. The training is provided by National CASA, and so what they do is they pick cases and things from all over the country, and then they make it so that confidentiality is kept. But because of that, some of the training work will say things like a PPC or a preliminary hearing or an evidentiary hearing, and we don't necessarily call it the same thing here in Kansas. For instance, a police protective custody hearing in Kansas is often a preliminary hearing somewhere else. We need to keep this in mind as you go through. Do not be afraid to ask questions, but I want you to be aware of this before we even get in. Now, one of the things that you will have received in the email is a list of acronyms, and I have it here. Don't worry about trying to put them all in there. There are actually more than what you see here. However, we keep this acronym list updated as new kinds of acronyms are created in our field, or we hear about them for the very first time. For instance, when I started with CASA in 2015, not many people had heard of a PRTF. Now, if you look at your chart real quickly, you'll see that's a psychiatric resident treatment facility. Now, that is mentioned in court all the time. Prior, no. So there are certain things that will age in and age out depending on new terms, new therapies, new behaviors, new titles, etc. So we always keep an updated list. You will have received via email that most updated list. But if you are in the courtroom and you don't know what something means, that's okay. We may not either, but we might know what it means. And if we do, we will share that with you as soon as you ask. So I want you to be aware of this as we go through the training so that you're not confused. I do say that there are a few acronyms that we typically use a lot. We use DCF for Department for Children and Families. And that is one that most people will use and most people understand. The other thing that you will see is CASA, Court Appointed Special Advocate. That one, CASA advocates, you'll see CASA a lot. The other ones that you will see on a regular basis is CINC, C-I-N-C. It is actually pronounced like sink, like the kitchen sink. But those are the child in need of care cases that we deal with. That is a term you will hear all the time and that you will really need to know. OJA, Office of Judicial Administration. They oversee all the courts within the state of Kansas, and so you will hear that fairly frequently. And then I'm trying to think, GAL, the guardian ad litem, that is the attorney that represents the child's legal best interest. Sometimes someone's legal best interest might not be in their overall best interest, so we want to make sure that we're really clear. They look after the child's legal best interest. They are not the child's attorney. The other one that you will really need to know, because you hear it frequently, is ICWA, I-C-W-A, the Indian Child Welfare Act. Now, we're going to get more into that later on in training. However, you need to know ICWA is how we call it, and it is said a lot. Now, those are your top ones. They're not the only ones, but they are the top acronyms that I would suggest you concentrate on making sure you know. All right, so what is the work that we do? Well, the mission of National CASA is to, together with state and local members, programs, promote court-appointed advocacy on behalf of children that are abused and neglected. Now, did I read that word for word? No, but you can read it on there. And don't be surprised if this changes somewhat soon, because National CASA is looking at updating their mission statement just to making it a little more inclusive and clarified. However, our local program, CASA, the 8th Judicial District's mission, is to advocate for the best interests of abused, neglected, and trafficked children in our court system. We strive to help children have safe, permanent, and nurturing homes. Now, this is what our mission is here at our jurisdiction in our program. If you are training with us from another program, find out what your local program's mission statement is. Now, all right, so let's talk just a little bit about the CINC court process. Remember, I just told you that's child in need of care. These are the kinds of cases for child abuse, child neglect, child endangerment, etc. And it all begins with an incident. Some kind of incident will happen. It gets investigated. And we're going to talk about how that happens in a minute. But it officially becomes a case once we have a petition. And now this is what you see on the screen is just a little bit of what a petition looks like. I have given you an example of a blank petition that is in the training. You can click on that, you can look at it. That is not something that you need to keep. That is not something you need to print out by any means. It is just for your information. This is what a petition looks like. All right. So let's go over that step-by-step process. Now, I will kind of give you a couple of different scenarios along the way, but we're going to act like the worst case scenario possible to bring us all the way through. But I'm going to kind of go through a flow chart, and this is kind of what happens just so that you're familiar. All right, first thing, some kind of complaint is called, or the law enforcement officers believe that there's a reason why a child needs to be removed. So let's stop right there. Let's say that we have a 2-year-old child who is left home alone for 24 hours. They are definitely too young to be left alone without any kind of supervision for that much time. If that is the case and a neighbor calls, then there's going to be an investigation. So a lot of times that might mean law enforcement is called to do a safety welfare check. It could mean that DCF is called and they send out their investigator right away. So what is going to happen is that complaint is called in, and then it has to meet certain criteria to be investigated. Now, if someone calls in a complaint that there's a 10-year-old playing in the background unsupervised, they're not going to necessarily recall to that, because a 10-year-old is allowed to play in the backyard with a parent inside the house just checking on them. That's not completely unsupervised. So you kind of get where I'm going here. There has to be a complaint filed of some sort, or something that is noticed, or some reason why DCF or law enforcement is involved with this family. That complaint has to meet certain criteria, and then if it meets those criteria, it's going to be investigated. So that's where they might send that DCF worker to go and check out that house and talk to the 2-year-old. Hey, where's your mom? Where's your dad? Your sister, your aunt, your grandma? Is there anybody here with you? That sort of thing. Okay. Now, they could find that maybe the neighbor didn't realize it, but the child had snuck out of the house when the mom or dad, when that parent snuck into the bathroom for 30 seconds to themselves, and didn't know that the child wasn't still playing, because maybe they were in the bathroom and then went to go make breakfast or something on that. And it's just one of those things that kind of happened that we're all glad everybody's okay, and there wasn't really a reason. If that is the case, or they don't find that there's sufficient reason, perhaps there were bruises on the child and they're like, no, I fell when I was playing a sport and I got all these bruises. It's not that my parents are beating me. And then they talk to the coach or someone else and they're like, yes, that child really did fall and we figured they'd have bruises. Great. Then the complaint is found to be what we call unsubstantiated. There's no evidence that any abuse or neglect has occurred. At that case, we're done. No case has been opened other than a DCF investigation. It's closed. Everything is good to go. But now what I said is we're going to actually kind of go through this as the worst case scenario. So let's say that 2-year-old is completely unsupervised. Well, then the next thing they do is they're going to substantiate. They're going to say, yes, we do have a situation here. Now they have to determine, is this enough? Is there a safety reason why this child cannot remain in the home? And this has to do with the Family First federal legislation. We'll talk more about this later, but I'm trying to feed you little bits as we go. That would mean that child potentially is without any supervision. If we can't get a hold of the mom or the dad or the parent or whoever is supposed to be with that child, we cannot leave a 2-year-old home alone by themselves. And if we can't get it in touch with whoever that responsible adult is supposed to be, we may not have a choice but to remove the child from the home. I will tell you, they try really, really hard. If it is just a risk to the child, they're going to try and put a safety plan in place and leave that child in the home. If they feel like they do have to remove that child, this is where they're going to try and find a kinship placement, whether it is related or non-related kin, to make sure that if we are forced to remove a child from the home, the next step is that they try and find a family, some sort of biological or non-biological family, so that that child is not traumatized. If that doesn't happen, or if we have a 2-year-old who doesn't know who those people are or how to get a hold of them, we may have to remove that child and put them into what we call police protective custody. Now, that brings us to the next step. If that child is removed from the home, they are going to continue in the background to put that child either back in the home by finding out who the responsible adult is, or B, finding a family member that could potentially have that child take care of that child while the case continues. If not, either way, they're going to have what they call a police protective custody hearing or a preliminary hearing. Typically, this is where parents are assigned. Attorney is assigned to the parents, a guardian ad litem is assigned, potentially a CASA volunteer advocate could be assigned at this point in time, but we can be assigned anytime from this moment on through the rest of the case at any point in time. Now, let's say that for whatever reason, that child, when we come to that first hearing, we feel like there's a huge safety risk and the child cannot go back into the home due to the safety concerns. They're not things that we can come up with a safety plan to protect the child with. Then within 72 hours of that hearing, and these are all the business hours, so from the time the child's removed, you have a police protective custody within 72 business hours, and then within another 72 business hours, you have what is called a temporary custody. This is the first time where the parents would have legal representation with them. They are going to find out if the Indian Child Welfare Act applies, ICWA, if at all possible. Grandparents should have received notice, all sorts of things. At that point, we are going to determine whether or not the child can safely be returned to the home or not. This is the first time where the parents may contest and say, no, we've got this fixed, we've got this situation, we've got that, or grandma's going to come live with us, or grandpa's going to come live with us, or my best friend's going to stay there. Whatever has to happen, or you may have a situation where it's not enough. When they went and they removed the child, they found there was a whole bunch of drugs or dangerous weapons or something in the home that provided a huge safety issue for the child, and that child needs to remain out of home. But a lot of times different things that can happen at that temporary custody hearing. They're really the first time the judge is looking at, can we put the child back in the home or not? They do want to try and put the child back in the home or in a relative kinship placement is what we call it, if at all possible. However, that is not always possible. And take a sip of my tea. Okay, now parents can do one of two things. They can stipulate, like, yes, I understand there's some, there were some issues and I couldn't take it. I get it that my child can't be with me right now until I get this, whatever it is, fixed or not. That's fine. They can stipulate and say, we understand the child can't come home right now. Or they could fight it, and then there's going to be a regular kind of evidentiary trial type hearing. That's going to determine whether the child can return home or not. Okay, after that hearing within 30 days, there needs to be an adjudication hearing. Any time between when the child is removed and that adjudication hearing, the case could go on a different track. And what could happen is it could be an informal supervision. So let's get a scenario. Let's say that one parent of that 2-year-old is a military, active duty military member, service member. We serve Fort Riley, so this is not an uncommon situation that one of our parents is active duty, or both parents could be potentially active duty military. If one of them is deployed and the one that's home, this stress got to them, they went, they got high, they got drunk, they got something, they didn't come home on time, whatever. Well, at that point in time, they might say, the military is actually pretty good about if a parent is deployed, they may take 2 or 3 days, but if they receive notice that a child has been taken into state custody, they'll typically, under most circumstances, get that parent that was on deployment back home, and then they could take custody of the child, and then we could return that child to the home. It does not mean the case ends, but it means potentially they would be going back home. There would be safety measures put in place. If they think this is a one-time incident, they don't think that it's going to happen again, what they might do is do an informal supervision for a 6-month period of time, and which means they'll set a court date for up to 6 months away, about roughly 180 days away, give or take a day or two. And as long as nothing else happens with that family during that 6 months, the case will automatically close at that 6-month hearing mark. If, unfortunately, something does happen, there's another incident or something else happens, and there's any more reasons why DCF makes another investigation, law enforcement has to make another investigation, etc., then that case will restart right at that point, and we don't have to go through the temporary custody and all that other things again. We will immediately restart the case. So informal supervision is available anytime up till the next hearing. Now, I wanted to talk about that. Now, the next hearing I do want to get to. However, it is not always the case that we are able to move that quickly. Why? Well, it's not because the court doesn't want to, and it's definitely not because the attorneys don't want to, but sometimes we might be waiting on a medical report, especially if there's physical abuse, doctor's reports, therapist reports. There might be a wide variety of things that have to happen first. And that could slow us down a little bit. Or a parent might be trying to decide whether or not they're going to contest what's happening. Remember back at that temporary custody hearing. And so we might need to subpoena witnesses. Well, that may take a little bit. Or we may have to publish because we don't know where to locate one of the parents, and we may have to publish in the newspapers, and then that has to be published so many weeks in a row. There's a wide variety of reasons, so it is not uncommon for there to have to be reviews or status hearing. Where are we? Are we going to go forward? Are we going to have this kind of hearing? Are we going to have that kind of hearing? What are your clients going to do to the parents' attorneys? Things like that will happen. When you attend your court observation, you will see exactly what I'm talking about here. There's a lot of discussion, and everybody's trying to move things through as quickly as possible, but sometimes there are delays because you have to wait for a certain medical report. I know that there was a medical test that took 3 months, and so they couldn't have that temporary custody, or they couldn't have that adjudication hearing until they got that witness from the medical test, because the parent said that there was something medically wrong with the child, and that was why the child had all the broken bones and things like that. We did find out that that was not the case, but it did delay the case because we had to give them the benefit of the doubt, because what if they are correct? And so then we would know one way or another. So that caused a delay, but during that time, they're still going to do a status on the case. They're still going to review the case. But typically, your adjudications will happen within 30 days. Now, I will be honest with you. What I'm about to explain to you is the most complicated part of the entire situation. And this is the adjudication hearing. And that is because I need to explain what a stipulation, a no contest stipulation is. And I'll be honest, although I hang out with lawyers, I am not an attorney, so keep that in mind. All right. So the parents have the choice of saying, no, I do not think my child has ever been a child in need of care. They also have the choice of saying, yes, I think my child was a child in need of care at that moment that this case started, but they're no longer a child in need of care. And then there are parents that could also make the option to say, yes, my child was a child in need of care at that moment and still now. Depending on what those parents do, depending on their choice, we will have the decision of what kind of adjudication hearing we will have. If they're saying, nope, our child has never been a child in need of care ever, this is ridiculous, then we're going to go on and we're going to have a trial type setting where the parents' attorneys are going to put on evidence, and then the state attorneys are going to put on evidence, and the guardian ad litem is going to put on evidence, and then the judge is going to decide whether or not that child is a child in need of care by Kansas statute. If the parents, the guardian ad litem, and the state are in agreement, yes, the child was at that time a child in need of care. Think of our 2-year-old that had one parent that did drugs or did alcohol while the other parent was deployed, and now we have the other parent back home and they're stable and they're getting help. Well, then the parents may not argue that the child, say, they may take the point where, yes, the child was a child in need of care at the time, but no longer, and we agree that the child was a child in need of care, and then the judge could potentially make that finding. It's, again, they're not going to object in that case. The first case we have a trial, the second case we don't need a trial. Now the third case is where I have to explain the stipulation, and that is basically the parent saying, nope, the child is not, yes, we understand that the child was potentially a child in need of care, but we don't need to go through the trial. Or yes, the child was a child in need of care, and we are not going to go through the trial, that evidentiary hearing. What they're actually going to say is that they're going to stipulate, they're going to make a no contest stipulation to whatever the state proffers. Lots of legal terms in there, so hang with me, okay? So what does that actually mean? That means they know that the state is going to offer a DCF report, potentially a law enforcement report, medical reports, any court reports that have come through. They're going to call witnesses to the stand about what was happening, what happened when why they took the child into care and et cetera, why the case started. And the parents are not going to say that those people are telling the truth, and they're not going to say that those reports and people are lying. What they are going to say is they're not going to contest, but what they are going to say is, yes, we believe that if called to the stand, that is what they will say. And my thing just went kerplooey. That yes, if those witnesses were called, if these testimonies were entered into the court record, that is what they would say. We're not saying whether that's true or false, but that would be their testimony. And therefore, we will allow the judge we will stipulate to that so that we don't have to call them all in here, and then the judge can make their ruling accordingly. That typically moves the case along quite quickly. You'd be surprised, very few people contest at this point, usually because there's enough evidence, because we've been so careful that there's a need for that adjudication. At that point, at that adjudication hearing, that is where the judge would officially declare that the child is a child in need of care under the Kansas statutes, and the case would continue. All right, we're going to continue to have more status and review hearings. We're also going to have a permanency hearing at least once a year. Note I said at least. Federal law requires that we have a permanency hearing at least once a year. That means that the feds are requiring us to at least look over this case and see what's going on with it at least once a year. What I will tell you is I am very thankful that we are in the 8th Judicial District of Kansas, because our judges really care about these children and these families, and therefore they review these cases much more frequently so that they don't have to wait so long to be ended, to be successful, etc. So don't anticipate that you're going to only have your case once a year. Okay, so that permanency hearing means we need to look at what are our permanency options as a child. Is reintegration just being delayed by, we're waiting on some things, or maybe the parents went into some kind of rehabilitation and they were in there for 3 months and now they're working their case plans and they're trying to work on housing or something else. These are all things. We're going to kind of evaluate where's the case going. All cases in the state of Kansas, first sync cases, are obligated to start with reintegration as our first case plan option. There are other ones, but those would come later. First, we always work reintegration if at all possible. So what's our progress on that case plan? That's what we're looking at permanency. Permanency hearings must be held no more than 365 days from the time that that child came into care. So let's say that that child came into care on January 1st, okay? Regardless of when the first hearings are, if that child came into care, was removed from the home on January 1st, then that particular child's case must have a permanency hearing on or before December 31st of the same year. Now, obviously, very few of us will want to be in court on New Year's Eve. However, it could potentially happen. So they have that as a date that they would have to have the permanency hearing. They could also do a permanency hearing anytime within that year, and they could do more than one. They just have to give notice to everybody. Now, why would they do that? Well, let's look at this, and we have parents who have abandoned their child. Let's say those parents completely abandoned that 2-year-old. We don't know who the 2-year-old is. We've tried to find the parents. We can't find the parents. There aren't any grandparents. There aren't any other siblings. Maybe we don't know anywhere we can find some permanency for this child. And we are now 6 months into the case, and we still haven't. We've published. We can't find parents anywhere. We can't find any relatives anywhere. And this child needs permanency. because child needed care cases are supposed to be in a child sense of time, and 6 months for a 2-year-old is a lot longer than 6 months to you and I. Therefore, we might make the recommendation, or someone may recommend, that reintegration is just no longer a viable option. After that has been done, if the judge makes the finding that reintegration is not a viable option because we can't find any parents, we can't find any relatives, there's no one to reintegrate the child with, we can look at that ahead of time. When the court makes the finding that a reintegration is no longer viable, within 30 days, the state needs to put a motion for a finding of unfitness / termination of parental rights out there. And it's a motion, it's paperwork that has to get filed. So reintegration found no longer viable happens first, and then we move towards, unfortunately, termination of parental rights. But if we don't have parents anywhere in the picture, we can't find them anywhere, we may have to move in that direction. So at that point in time, when the case plan changes from reintegration to potentially adoption in this case, that means that we are going to need a new permanency goal or permanency plan, and so we would have another permanency hearing within 30 days of that. Typically they do it when parental rights have been terminated, so you have that RNLV, we call it, reintegration is no longer a viable option. Then we would have a motion for a finding of unfitness is the actual motion that is filed, but if the judge finds that the parents are unfit due to abandoning the child, then what would happen is they would say, and it's in the child's best interest for the parents' rights to be terminated so that the child can have permanency. Sometimes you may find there could be a finding for that the parents are unfit, but not to the point where we would which would merit termination of parental rights, and usually we're going to look at an alternate permanency option. We will talk about all of that later on in training. But what will end up happening here is we are looking at, they will set a new permanency date, and that permanency date from that time that they do that adoption, then that becomes the 1-year mark for everything. Okay. There's going to still be, and you see TPR if no reintegration, you're still going to have reviews and statuses, and CASA volunteer is still on the case at this point until the case is actually terminated because the child has aged out of the system, the child has been adopted, or the child has had a permanent guardianship, custodianship. So there are other permanency options in the state of Kansas. One of those permanent options has been fulfilled, and the child is no longer a child in need of care with the court. Once that happens and the case is officially closed or terminated, that is when you are off the case and ready to take your next one. All right. So, and we are going to move immediately into what happens in a JV case, a juvenile offender case. And I just want to go over this briefly because you need to understand some of our child needed care cases. Also, those children also have a JV case at the same time, so we always want everybody to be informed. So the juvenile would be arrested or detained at some point, and then there are 3 options. They could be counseled and released, and so basically they've gotten a warning, they've gotten a talking to, but nothing official has been done. They may get, they might be, 17 and a half, it might be a serious crime, and they might decide to try them as an adult. At that point, they are part of the adult criminal system, and they are not part of the juvenile system. The third option is that they could be referred to juvenile court. That means that there's officially going to be kind of a case opened, and then we have 5 options. They could do an official intake, and then the case gets closed there. This is another one where that counseling isn't going to quite do it. It might be a little more serious crime, so they actually open a case so that there's a record of the case, and then they close it. There might be some informal probation, and I'm using terms like probation, although now it's typically called supervision. Most people understand probation, and we'll kind of be talking about these things as we go through. They could be a diversion. So I don't know if any of you have ever had a speeding ticket and then you pay an extra fine for a diversion fee and it doesn't come up on your insurance costs or on your record. I will tell you it is there someplace, but most people can't find it. They might pay a fee and then it's as if that case has never been filed. Depending on what it is, I will tell you that we have found all sorts of things. Our background checks for CASA volunteer advocates and staff are so substantial that every once in a while OJA will say, hey, there was something in their youth that we might need to clear up first. So it might be transferred. So the incident may have happened here in Geary County or Dickinson County, or it might have happened in Wyandotte County or Johnson County, and they realize, oh, this child has a child in need of care case in Morris County. We're going to transfer our juvenile offender case to that county because they're already out there and they would be the ones that have the service. So it could get transferred to or from our court system. And then I always save the worst option for last because we always hope it doesn't get here. They may file a petition, which means that the youth officially enters the juvenile justice system. Trying to clear things up and do them before it's actually filed, but it may still end up happening. Okay, this is where the judge is officially going to have to decide, is the child officially, and I will say, ruled a delinquent does the case have enough merit to go forward? So no, they're not going to charge the youth with a crime, and they're going to, but I mean, it's still in their record. There's going to still be some consequences. Usually there's some kind of supervision. We'll go back to like kind of that, it'll be a formal supervision or something on that idea. Yes, if it has made it to this point, most of the time the answer to this is going to be yes, they are going to get charged with a crime. It's a matter now, is it a felony or is it a misdemeanor? If it's a misdemeanor, it's going to be presumptive community-based programs, community service, that sort of thing, or it's going to be sanctions, as in they have to make restitution if they shoplifted, something like that. And then they're going to be on probation. That kind of supervision is going to still be a case. If, however, this is a felony, there are two options. One is a juvenile correction facility, and that is a lesser holding area for children. It's serious, but it's not the worst of the worst. They may also have a community correctional facility. This is not what we call a juvie so much as this is like adult prison, but it is just children. And then after they would be released from that, they would go to presumable post-release supervision, probation, that sort of thing. That is how that system works. We won't deal with it a lot. If you have a case that does touch upon it, obviously that's the time we'll get into much more detail. So who's involved in a case?